All right, here we go.
Thank you, everyone. Please be seated.
Here we go. This is the moment. Judge Darrell's gonna give her piece. I could not be more excited about this.
We are back on the record in State versus Brooks. Appearances are as they were before. I want to give you all a little bit of my roadmap for
Why is he looking angry now?
remarks here today and what will ultimately conclude with the sentencing. I'm going to start with a review, frankly, of Mr. Brooks's NGI plea. Now, I wasn't going to start out doing that, but I feel compelled to make a record of certain things in light of many of the statements that were made here today by Mr. Brooks and his family. Following that, I'm going to talk about the case, the strength of the case, the witnesses and evidence that was presented, and some of the things that really impacted me throughout that time and throughout the nearly 4 weeks of trial. Then I will spend some time talking about the victims, their victim impact statements, and again, things that have stood out here to me. I cannot comment on all of the victim statements that have been made, but there are a few that I do want to highlight. And then ultimately, go through the sentencing factors. Because all of these things that I'm going to talk about relate to those factors, which in Wisconsin there are 3 primary factors: the seriousness of the offense, the need to protect the public, and the character and rehabilitative needs of the defendant. So I want to start sort of near the end of all of the remarks over the last couple of days, and that is with my thoughts on Mr. Brooks and his mental health. I'm not here to debate that you have had a history over time of intersecting with the mental health agencies and that you may have in your history trauma, emotional pain, and things of that nature. I have read through not 1, not 2, not 3, but 4 reports from experts, people who are well known in this field of what we call forensic psychology and psychiatry, individuals who have an expertise in evaluating a plea of not guilty by reason of mental disease or defect. Because I don't want there to be any doubt in my sentencing here today that I've considered that.
Right.
But I also don't want there to be any doubt that somehow this trial was missing something. Because the fact is, Mr. Brooks entered a special plea of not guilty by reason of mental disease or defect in the early summer, maybe late spring of this year. And this court ordered 3 court-ordered evaluations, and the state retained an expert to also review the issue. Whether the defense team at that point ever hired anyone, they are not required to disclose that. I don't know, but I have 4 well-known doctors who have written this court based upon the orders that were made or one doctor being retained. And these are reports that are thorough. One report is 24 pages. Another is more of a summary. It's 8 pages. Another is 26 pages. And then another is 12. And they look at the discovery information, so police reports, videographic evidence, things of that nature. They have access to any mental health related records from prior stays or things like that. They look at a history. They meet with Mr. Brooks. I've referenced this in the past when competency wasn't so much raised by any of the parties here, but during the trial there was, as Attorney Opper wanted to make a record one day of Mr. Brooks's competency. And I will restate what I stated at that point. I have absolutely no doubt that Mr. Brooks is competent. I'm obviously well versed in the legal standard, but that is not something that this court was frankly ever concerned about at any point in time. I know that his attorneys, when he had attorneys, never raised the issue. And it was really only after the trial began that that issue was raised, I think, by the public based upon what they saw. But Attorney Opper, like myself, had the benefit of having reviewed each and every one of these examinations. And I'm not going to spend a lot of time, but I think it's important because it goes also to Mr. Brooks's character, which is one of the things that this court must consider along with his rehabilitative needs.
I am so happy that this is a part that we are reviewing. I never doubted that she would review this portion of his files or anything. So many people told me that he tried to do this early on, and I thought for a second, like, okay, this guy clearly something is off with him, like he's not mentally well. So he doesn't have a mental illness, he just has a personality disorder, which essentially means he doesn't feel empathy for other human beings. He literally just feels like he should do whatever he wants, and he thinks the world revolves around him. Now, that's not an exact definition of it, but as I started to look into that stuff, I was like, yeah, this is Darrell. Like, he does not care. He says literally whatever he thinks he should to try to get out of a situation, which is another characteristic. They lie a lot. Thank you to everybody that let me know about that. But essentially, Darrell is just a monster. He doesn't have a mental illness.
And I'm gonna read parts of these evaluations so that you all understand the information that I have and why it is my opinion that mental health issues did not cause him to do what he did on November 21 of 2021, and frankly did not play a role. That's not to say that he wasn't diagnosed with something. I've referenced this previously, but that's an antisocial personality disorder. And this is what one of the reports has to say. They've looked at one doctor indicated that there was available evidence to sustain a diagnosis of cannabis abuse, intoxication, antisocial personality disorder, adjustment disorder with mixed disturbance of emotions and conduct. And the reports go on to describe what those things are and that they may qualify as an abnormal condition of the mind substantially affecting mental or emotional processes, and thus as a mental disease or defect as broadly defined by the Wisconsin jury instructions, and that's at least as to the adjustment disorder. Cannabis abuse or intoxication would not. The diagnosis of antisocial personality disorder, and this is what the doctor said, reflects converging support of an underlying characterological disorder versus a major mental illness. In Mr. Brooks's case, I would note his history of disregarding the rights of others and conforming to societal norms, including in the forms of multiple acts of violence beginning in his youth, contacts with the criminal justice system, lack of remorse as indicated by being indifferent, rationalizing, etc. The doctor goes on that it's her understanding that this characterological condition would not qualify as a mental disease or defect as defined by the applicable statute, which also specifies that mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Goes on to talk about her opinion regarding criminal non-responsibility. And the examiner rendered an opinion to a reasonable degree of professional certainty that there was not support for the defendant's special plea, that the facts at hand do not sustain a conclusion to a reasonable degree of professional certainty that because of symptoms of a mental disease or defect, Mr. Brooks was rendered to lack substantial capacity either to appreciate the wrongfulness of the alleged misconduct or conform his conduct to the requirements of the law at the time in question. In arriving at this opinion, the following considerations were significant to this examiner. While acknowledging Mr. Brooks' documented history of episodic contacts with mental health professionals beginning in adolescence. Most of the time he has had such contacts or received mental health treatment when in custody. In effect, there is not a sustained, documented history of a diagnosed major mental illness for him predating the alleged offense or otherwise. Looked at a psychiatric review from April of 2010. At that point, the defendant was determined to have no medically determinable impairment on which to qualify for disability benefits. The consultant who conducted the review noted that Mr. Brooks' claimed mental illness was not, quote, well established, quote, that the statements that he made at that point were not deemed credible, they were inconsistent and not verified by treatment providers in the community. Factor number 2, the defendant's history of violence beginning years predating the alleged offense is significant. He faced multiple prior domestic-related charges. He was not permitted in his mother's home because of the history of violence. To be sure, the magnitude and lethality of Mr. Brooks's violence in the commission of the alleged offenses is more severe than what was previously known.
This is one of the reasons why, and I'm sorry to cut her off in the middle, that I have no idea how within all of this stuff, he hasn't gotten like a 20-year sentence or 25 years. But the fact that he wasn't even allowed into his own mom's house, like just seeing that, I felt like I knew everything that we needed to know.
However, the defendant's history of a pattern of violent behavior, coupled with other aspects of his history, and this case strongly suggests that his mental state, which produced the alleged offenses, was most fundamentally formed and fueled by contributions of his underlying characterological dysfunction, anger, and rage born of his conflict with his girlfriend moments before the Christmas parade tragedy. The examiner considered Mr. Brooks's episodic endorsement of auditory hallucinations, including on clinical interview with the undersigned, meaning the examiner, and in a couple of recorded jail phone calls subsequent to his arrest. She said this, "I am unaware of any objective corroboration that he presented, either in the hours leading up to or following the alleged offenses, as internally preoccupied or otherwise exhibiting signs of impaired reality, contact, or behavioral discontrol. To the contrary, the defendant's conduct within hours of the onset and moments following the alleged misconduct was organized, controlled, and purposeful. Moreover, he demonstrated the motivation and capacity to take efforts to evade detection and try to flee the immediate area of the parade carnage." She went on, "I have considered the seemingly inexplicable nature and magnitude of the violence and mayhem wrought by the defendant's conduct on the day in question. He has caused 6 deaths, dozens of injuries, and terrorized hundreds of parade participants and thousands of spectators. There is no indication in the extensive compilation of records and other information available that at the time of the alleged misconduct, he lacked substantial capacity to either control or conform his conduct to the requirements of the law, or that his reality contact capacity to appreciate wrongfulness was substantially impaired. In the context of rage born of his conflict and altercation with his former girlfriend turmoil, the defendant was disinclined to control his behavior or attend to its consequences. Notwithstanding the magnitude of the violence in this case, a mental disease or defect is not defined by the unnaturalness or enormity of the act. Moreover, temporary passion or frenzy prompted by revenge, hatred, jealousy, envy, or the like does not constitute a mental disease or defect." She goes on to talk about the course of functioning of Mr. Brooks during the day leading up to the alleged offense, does not suggest that he was behaviorally dysregulated or that his reality contact was impaired. Goes on to talk about what he did in the immediate aftermath of the parade, including fleeing the vicinity, making efforts to evade detection or responsibility.
It is so creepy how he holds a single pose and does not move. That in and of itself, can we please add an additional 20 years? That creeps me out every time he does it, but okay.
And other things. Went on to discuss other evidence, including the videographic evidence of the Ring doorbell and being on the porch where he sought to use the phone. He had apparently discarded a couple of small bags, later determined to contain marijuana. And presumably, this is the examiner again, he discarded items to evade responsibility for possessing them. By implication, such conduct strongly suggests his capacity to appreciate wrongfulness was then intact. When responding to law enforcement officials, he followed their commands. He lowered himself to the ground. We saw that on the recording of his arrest when he was taken into custody and detained. None of the behaviors nor verbal remarks at the time of the arrest suggest he was behaviorally dysregulated or that his reality contact was impaired. Following his arrest and being taken into custody, he engaged in an informal series of verbal exchanges with authorities, and none of his statements taken at face value suggest he was then actively psychotic or that his behavior controls were substantially impaired. She then goes on to talk about the Mirandized statements. This court personally watched every minute of that interaction with Detective Carpenter and Detective Stern, along with the one from the night before, which was at the hospital within hours. And I would concur with the examiner's conclusions that the content of his initial statements to authorities included multiple efforts to deceive or mislead. He changed his story multiple times, including he initially denied being in Waukesha the prior Saturday. He initially asserted he traveled to Waukesha on the day in question in a tan Kia with a friend. He initially asserted his mother did not own a vehicle, though later acknowledged as much, and that he used it from time to time. Other changes in his story over the course of his statements and the nature of them further suggest that he was making active attempts to evade detection or responsibility. By implication, such behavior strongly suggests that his reality contact was then intact. When he was shown photographs of driving in the SUV into the parade route, he indicated it was not him. And this is again the examiner. With the police. She's noting the police contact. It was not until Mr. Brooks was in the booking area of the Waukesha County Jail that he displayed some emotion, and this was to, I believe, Detective Stern, where he said, "I didn't mean to kill nobody." Such a remark indicates an awareness of the consequences of his actions and runs counter to a conclusion of an exculpatory mental disease or defect. There's other criteria or other factors. I'm not going to read them all. That was probably one of the more comprehensive explanations of why that examiner did not conclude that there was support for the special plea of not guilty by reason of mental disease or defect. All four examiners shared similar observations. Certainly their conclusions were that there was not support for the special plea. One examiner talked about, again, conduct after driving through the parade, abandoning the vehicle used in the act, altering his appearance by removing his outer layer of clothing, altering how he was wearing his hair, and then engaging in further efforts to leave the scene by securing transportation via a ride-sharing application.
Which his mom paid for.
This particular examiner went on to say, while he essentially, meaning Mr. Brooks, disclaimed any memory of those actions and could therefore not explain them, such behaviors strongly suggest an awareness of wrongdoing and a desire to avoid detection. Another examiner had very similar things: antisocial personality disorder with borderline features, talked about the cannabis use disorder and full remission in a controlled environment. What's interesting about this particular report is the description of an antisocial personality disorder. The DSM-5 defines antisocial personality disorder as a pervasive pattern of disregard for a violation of the rights of others occurring since age 15 years, as indicated by 3 or more of the following: failure to conform to social norms with respect to lawful behaviors, as indicated by repeated performing acts that are grounds for arrest. 2, deceitfulness, as indicated by repeated lying, use of aliases, or conning others for personal profit or pleasure. 3, impulsivity or failure to plan ahead. 4, irritability and aggressiveness, as indicated by repeated physical fights or assaults. 5, reckless disregard for safety of self and others. 6, consistent irresponsibility, as indicated by repeated failure to sustain consistent work behavior or honor financial obligations. 7, lack of remorse, as indicated by being indifferent to or rationalizing having hurt, mistreated, or stolen from another. In addition, the individual is at least 18 years old and there's evidence of a conduct disorder prior to the age of 15. This examiner noted Mr. Brooks meets nearly all of the symptoms described above because he has exhibited a long-term maladaptive pattern of behavior involving a disregard for and violation of the rights of others.
I was going to say, I thought she was, I was just going to say, he meets every one of those criteria. Every one of them, that's Darrell. But okay.
In childhood and continuing through adult life. The borderline features reflect a general inability to sustain healthy relationships with others, including his domestically violent relationship with victim PPP.
That must be Erica.
That examiner goes on with further analysis and conclusions, again finding that there is not support. The last examiner, again, made similar conclusions, also diagnosing Mr. Brooks with an antisocial personality disorder. Why is that important? There is no doubt that in our criminal justice system today, we face a crisis of the mentally ill intersecting in our courts. In the last year and a half alone, this court has ordered many competency evaluations, presided over a number of contested competency hearings, and ordered many, many evaluations for the special plea of not guilty by reason of mental disease or defect. And the bottom line is, for this court, Mr. Brooks does not present as a person who is either not competent or not guilty by reason of mental disease or defect. It is frankly heartbreaking to see those individuals who truly suffer from schizophrenia, for example, intersect in our criminal justice system. Sometimes they do unspeakable things. They hurt other people. I'm thinking of one such gentleman who was so schizophrenic and out of control. He couldn't even be kept in the courtroom. He was too loud. He clearly, if you've ever been in the room with someone who is suffering from auditory or visual hallucinations, it is not something you easily forget. It makes an impression, even on someone like myself who's not an MD or a doctorate level psychologist.
Oh boy, I really hope that Darrell doesn't take this as, oh, so this is the way I need to act right now so I can get an insanity plea. I have a feeling at some point here, he's going to start screaming because right now she's telling him he does not have any mental illness. And Darrell doesn't like when you don't believe him, when he lies. So yeah, we're on the way to that.
I've been in the room with an individual who was, when I did defense work, and he was accused of killing someone near and dear to him. It's a very, very different presentation It's heartbreaking. It's heart-wrenching. Do the mentally ill sometimes commit atrocious crimes? They do. This is not one of those situations. We've heard Mr. Brooks's family talk about mental illness and bipolar. You know, in addition, before I get to that, I've also had, over my 11 years on the bench, of coming face to face with evil on occasion. There are many times, good people do bad things, but there are times when evil people do bad things. There is no medication or treatment for a heart that is bent on evil. Child trauma, bipolar, indifference, physical abuse of a child, or even childhood trauma did not cause Darrell Brooks to commit the acts for which he will be sentenced here today. It is very clear to this court that he understands the difference between right and wrong, and that he simply chooses to ignore his conscience. He is fueled by anger and rage. Some people, unfortunately, choose a path of evil, and I think, Mr. Brooks, you are one of those such persons. As a mom, my heart breaks for your family, for your mom, and for your grandmother. The son that she raised, the grandson that your grandmother knew, the hopes and dreams they had for your life, they're gone. And I think it's perhaps far easier for them to blame a mental illness than to perhaps come to grips with their son did very, very bad things due to very bad motivations. One of the things ultimately that will happen when you are in prison, sir, is that the Department of Corrections, they are statutorily responsible for your care and your well-being, including your mental health. I do not have any authority to dictate to them where you go or how they treat you. That is far different than when there is support for a plea of not guilty by reason of mental disease or defect, because then the court has available what is called treatment facilities and a commitment to such a treatment facility. That is something that is simply not on the table. And again, 4 evaluations, not even my own assessment, but 4 evaluations from licensed professionals say otherwise, even in the face of your family saying that, and even in the face of you claiming that. I'm not even here to say that some of those things can't coexist, and you might not have some of your own mental health issues, whether it be bipolar, childhood trauma, or things of that nature. But the bottom line is none of that caused you to do what you did on November 21 of 2021. I want to next turn to
He's such a weirdo.
the trial in this case.
He's just sitting. Okay.
And I think it's important that the sentence here today focuses on your conduct on November 21 of 2021 and the moments leading up to that tragic and fateful decision of yours to drive through the Waukesha Christmas parade, and of course the moments after. I, of course, through my sentencing remarks and ultimately what I do here today, I can't answer all of the questions. I can't address all of the issues, including the why. Perhaps the one question that will remain unanswered. Why? Why did you barrel down White Rock Avenue? Why did you not stop? Why did you keep going? Many of us in this courtroom sat through the entire trial. And what we learned is that very early on in the afternoon of November 21, starting at around 1 p.m., the police got ready for the parade. The staging area was set up, and that was all along White Rock Avenue. Signs were put in place. Ultimately, barricades were put up at a number of locations on Main Street and surrounding that. We know, because we heard from Sergeant Warner about what he had done, and he had, right before the start of the parade, had driven down the parade route. It was on his shoulders, his responsibility to make sure everything was safe and in order. What's important about that staging area, sir, is we know that that is where the altercation with Erica Patterson really came to a head. We all watched that video, multiple videos.
Right.
And we know that even before that, you appeared angry and upset. 2 individuals testified about you being at that mobile gas station, how you turned the wrong way down a one-way street, waved your hands in the air, rolled down your window, either exchanged gestures or words with one of the drivers. Perhaps 30 minutes or so before the start of the parade, maybe an hour or so before you drove down the parade route. But what's important is the signage. Even you, at one point, I believe when you were talking with Detective Carpenter, noted, it was my words, my assessment, it was clear something was going on. I think what you said was a lot of shit was blocked off. You'd driven past those signs on the staging area. The fact remains they were there, sir. And the fact remains is you told Detective Carpenter that. We then heard from the witnesses related to Ms. Patterson. We heard from Corey Runkle. We heard from Erica Patterson herself. My impression, based upon Erica Patterson's testimony, who, by the way, she showed grace and dignity facing you, the man who clearly has no regard for her as a mother of one of your children, as someone you had a domestic partnership with and a relationship with at one point.
That's not true.
We know.
He's starting to talk now. He's ramping himself up. You all know how this goes. He starts with a little bit, and then it's just, he starts to make himself angrier. I'm so happy she just said that. She is breaking down everything that this guy is, so I'm not gonna continue cutting her off, but I'm pretty sure he's about to start screaming.
And I would say this goes to your character. What was shown through that altercation and going up the hill, following her, slapping her. You know, the rules don't matter to you, not the rules of the road, not the rules established by court orders, not the rules even of decorum and decency. And I'll get to this more fully when I talk about your character. And I know you went hard at Attorney Opper for her bringing these things up, but those are legitimate, lawful sentencing considerations. And when I get to that point, I'll tell you the case law that supports that. Your character, even your pending cases.
I don't need no case law.
Cool, bud.
We know at the time of all of this, right, you were out on bond for 2 felony cases, one involving a handgun, one involving the same vehicle and Erica Patterson, and one involving ultimately intimidation of Ms. Patterson. We know that on November 20th, and she was very contrite about this. She told you where she was. She invited you out there. And that you had contact with her on the 20th There was
Never
some
had
physical.
contact with her on the 20th.
Mr. Brooks, this is my time. You
That's the
need to
reason-
not
That's
interrupt.
the reason why the charge was dropped.
Mr. Brooks,
because the state
you need to stop.
said specifically, wrote you, Your Honor, and said that they know it was no incident that day.
Mr.
And now
Brooks,
you want to sit up here.
do not
and now
interrupt me or you will be removed to the other
and now you
courtroom.
want to sit up here
Stop.
and try to
now.
add something in that you know for a fact never even happened. You want to sit up here
Mr.
and talk
Brooks,
about
every
who has
time-
grace and all this. You talking about someone with 5 kids that don't have custody.
You need to stop
None of
right
them.
now or you will be removed.
Remove me then.
All right? He will be removed. He cannot simply stay
I don't
quiet when
consent
this
to being
court talks.
sentenced anyway. I don't consent to this. Just like I told you, I don't know the.
We'll be in recess until he's
I don't
removed
even
to the other
understand
courtroom.
the true nature and cause.
And that's okay, Darrell. That is A-okay you don't understand, bud. But you will understand that 1,000-year sentence. I'm sure every minute of it, you'll fully understand that. You don't have to understand this. Yeah, I knew he was starting to ramp up there. As soon as he cut in and he knew like, oh wow, I'm talking right now. He always has a moment like that. He shuts up and then he realizes, like he hears his own voice and he's like, oh wait, I can make noise and this stuff happens. Okay, let's scream. Absolute coward. Let's go ahead and see him sit in the other courtroom. Okay, hold on. I saw something really quick. Look at this absolute clown, dude. All right, there's a thumbnail for us right there.
Brooks is able to hear and see the court. We do have the audio and visual on. If someone, I can see on the screen there is a headset on the table should he choose, but I have confirmation that the audio and visual are working in the other courtroom. Before I continue, of course, Mr. Brooks does have a right to be present for his sentencing. He's been present all along today up until his disruption. It was very clear to this court that he had absolutely no intention of stopping his tirade. I think there's really no other way to describe it. And this court needs to go through its remarks uninterrupted. And given the history in this case, which is well documented, of his disruptions and inability or unwillingness to follow the very simple rules of decorum and courtesy, which include not interrupting the court, I felt it important under Illinois versus Allen to remove him from the courtroom. As that is, of course, one of the options, and we have the benefit of the wonderful technology here in this courtroom and the adjoining courtroom, which I believe is the equivalent of being present, what I have referred to at times during this trial as the functional equivalent of being present in this very courtroom. But it is important that I go through this without interruption to make the record that I need to make. I'm going to backtrack. No, you're not muted, sir. You're going to listen to me, and you're not going to interrupt. So I want to, I don't want to call it a tangent, but I'm looking for a note that I made.
I would like to exercise my right to be present.
Then you need to pledge to this court, sir, that you will not interrupt me despite what you may not like me saying.
No.
Can you do that?
I would like to exercise my right to be present.
All right, he's not making that pledge, and under Illinois versus Allen, unless he makes that pledge, he's not coming back into this courtroom. You are not.
Please, no.
I would like to exercise my right to be present.
All right, clearly he's going to keep repeating that statement,
Yes.
so I have muted him at this point. It was my hope that he would honor the simple rule of courtesy and decorum that he show respect to this
I
court.
really hope that right here at the end, he's not going to come in and out of the courtroom, because we've seen this already. He literally just does this to try to prolong and stretch this out as much as possible. I don't know if he just doesn't want to be officially sentenced yet. I mean, I'm sure that's what it is, but this is, if he could do this forever instead of just going to prison, I'm sure he would do that, because for some reason this is what he wants to do, to just play a little game before he gets put into a small cell for the remainder of his life.
To these proceedings and not interrupt and talk over me, but that clearly is something he is unwilling or unable to do. I'll find my note that I wrote later. It had to do with, frankly, what this court has observed as a pattern with Mr. Brooks, and that is when testimony or statements by the court or statements by the prosecution team become unfavorable to him, he lashes out and he disrupts. And that has been borne out time after time after time during this trial. So let me go through and pick up where I left off about the trial. I'm not going to go through everything in detail, but I think it's important that I set the stage, right, and the basis for my sentencing. One of the things that I did note regarding Erica Patterson's testimony, because frankly I wasn't sure where Mr. Brooks was going to go with his own defense based on some of the remarks he made during his opening statement, which was actually later, but I guess I'll go back to my review of his recorded interview and some of the things that he tried to say, and at least it became apparent ultimately with the way he cross-examined witnesses. I wasn't sure if he would claim perhaps someone else was in the vehicle, he was afraid of police, the tinting of the windows, some of those things. Here's where it frankly doesn't matter, okay? Erica Patterson provided key testimony in this regard, that there was no one else in the vehicle with Mr. Brooks. And I'm aware that he wants to come back, but until he writes me a pledge that he will not interrupt me under Illinois versus Allen, he is not coming back in this courtroom. He has forfeited his right to be present during my remarks. And unless he makes that pledge to me in writing, he's not coming back in.
Please don't let him back in. Even if he writes it, just pretend you don't get it. Pretend it never arrived.
One of the things I tried to do in my preparation, and let me tell you, I reviewed all of my notes from this trial. I have, I think, 9 notepads. I looked at just a couple of exhibits, but primarily the map, Exhibit 15. I really wanted to determine for myself how long this carnage took. We know the distance, right? From at least where he entered. And you know what, Madam Clerk? Put my screen up, will you?
Sure. Let me see. So we're in video conference.
I'm going to put Exhibit 15 up because I think it's worth doing that.
Exhibit 15.
Right. We know he entered from White Rock, where the first star is on the right side, where it says Fleet 1, unmarked sedan and marked SUV. And that's where Detective Casey was. And so we know he goes 1, 2, 3 blocks before striking anyone. And then it's really about 5 blocks of what can only be described as chaos and carnage. We know we have, from the evidence and the testimony, 2 different speed calculations. One from Bosco's, that was the surveillance footage, between 33 and 34 and a half miles per hour. And then we have one farther down from the footage from Curry Insurance where it was an average 32 miles per hour. Now, I acknowledge math is not my strong suit. I did not do a calculation, but I don't think it took very long for all of this to happen. I think it was a matter of minutes. I think 5 minutes would even be far too long. It's probably 3,
Right.
maybe. And it was somewhat hard to gauge during the trial because of how the state presented. And I don't mean this as a criticism, but they were very meticulous in showing video, breaking it down, showing it at half speed, sometimes 30% speed, to really get an understanding of what was happening.
And that's very true. The amount of information that the prosecution was able to provide, it did make it seem as if this took way longer than it actually did, because I'm sure the process from the beginning of the parade route to the very end, it probably took less than even 3 minutes. Like, the evidence not only showed he was the one that did it, but it painted the full picture.
And at no point did anyone ever tell me or tell the jury how long this took. But even though it took just a couple of minutes, there were so many opportunities for Mr. Brooks to simply stop, turn around, turn down other streets before he ever crossed Barstow Avenue. And what we know is that at 4:37, Detective Tom Casey had the first police encounter with Darrell Brooks. Came face to face, Detective Casey at the hood of the car, coming eye to eye. The SUV brushed past him. And here's the thing, Detective Casey said he wasn't going very fast. To me, that tells me he had ample time to reflect about what he was about to do. If you look on that map,
Please throw it away. Throw it in the garbage.
it's not a pledge, he's not coming in.
Nice. Perfect.
When you come down White Rock, you can take a hard left on East Main Street. You can take what I call a soft left. I believe it's Pleasant Street. And Detective Casey, you can correct me if I'm wrong. I can't see it on the map. Frankly, you can turn around at any point in time on White Rock Avenue. But instead, and I think if you all try to picture this, as difficult as it may be, there's squads with lights, there's barricades. I know I read in the other act's motion that Mr. Brooks claimed at one point he was having a panic attack, and he, again, maybe I think he was going to claim at some point he was afraid of police. Why drive toward them? Why take that right-hand turn? There's no reasonable explanation other than he was angry, he was full of rage, and he didn't care who he came in contact with, what he came in contact with, whether he drove past, through, at, he drove.
Exactly.
Detective Casey pounded on the hood of that car, saw his face, again, was brushed by that SUV, thankfully not hurt. All of this preceded by the visual signs along White Rock Avenue of the staging of this parade. Floats, bands, banners, signs, people. And as you got closer to Main Street, the spectators lining those streets, which both, I believe, Detective Casey and Sergeant Warner said were thousands of people. Before he ever gets to Barstow Avenue, he comes in contact with, after Detective Casey, Officer Buttrin and Officer Schneider. He has an opportunity, if you look at this map, he could go right on Buckley. Again, there might be police, there might be barricades. You simply stop. You ask, can I get out? No doubt in my mind, any police officer there would have done just that.
Right.
He could have gone left on Northeast Avenue, continuing down. He could have gone left on Martin Street. Continuing on, Barstow Avenue. This is where the parade participants, unfortunately, he has contact with them, but he could have gone right on Barstow. He could have gone left on Barstow.
Can we please just take the
And we
camera off
know
and this no
from some
point?
of the footage that we saw that his car was seen flying past, true, not hitting one at this point, but flying past. There's no logical understanding for Mr. Brooks other than he's in the middle of a parade and he can see them. Anyone driving a vehicle would see what's ahead. And we know from this map, right, what was ahead of him. We saw that video footage. We heard the testimony. Many police vehicles at these intersections with their lights flashing. There's no doubt in my mind that Mr. Brooks would understand a parade was going on. You can turn off my monitor, thank you. We also know it was not yet dark. Dusk. This was from the battalion chief who talked about when he arrived after that first alert at 4:39, it was not yet dark, it was dusk. I think that aids to the visibility that Mr. Brooks would have seen all of these people. This is not under cover of night.
Right.
It's, of course, downtown Waukesha. We saw city lights and many of the street lights I'm referring to in many of the videos as well that would have been on or coming on. We know just past Barstow, he strikes his first victim, Nicole White. She was with Remax Services with the hot air balloon. If anyone's seen that, we saw it in the video. That is unmistakable what that is. That would get anyone's attention. If this was a mistake, if he was lost, this was his very first opportunity to stop and do the right thing after causing injury to a person. But he didn't. He did not stop. And then, of course, the Waukesha South Band. It's hard not to think about what I watched and not have this reaction. Those were images that frankly kept me up at night, that I saw over and over and over. For their band director, she is a hero to me, to get up on the stand, to talk about, and that was Sarah Waymeyer Aparicio, to identify each one of her students, talk about their formation, talk about what she saw. So strong for all of you. Mr. Brooks had another opportunity to stop. This wasn't one isolated person that he could claim, I didn't know I struck someone. This was driving over people. What Kyle Jewell described as the SUV went over people like they were big old speed bumps. I know the Green children were injured around there. Thankfully, their physical injuries were minor, and I know I could probably spend a long time talking about the injuries of the band members, and I'm not gonna go through that. They were significant. It was horrific. Thankfully, none of them were killed. And then, of course, moving on to Burr's Logistics, between the band and the Blazers, that is where Kelly Graybow and her 10-year-old daughter, Adelia, were. in that adorable Cindy Lou Who costume. And what struck me, and Kelly referenced this in her statement yesterday, was seeing the tires go past her head after she was hit. Delia had major injuries as well. And then, of course, the footage from the Waukesha Blazers. And Jeff Rogers talked both at the trial, he testified, and he gave a statement yesterday about, again, having to come into this courtroom, talk about all of those who were with him, who were injured, and of course, little Jackson Sparks. Another video that frankly is very difficult to watch and hard to unsee. You heard not only Jeff, but Josh Craner talk about what happened, and Josh, of course, being struck. And then the extreme dance group. I think it's fair that I didn't fully understand the extent of their injuries until hearing from many of the victims yesterday.
Same here.
I now understand why one of the girls called her aunt and said, "My entire team is dead," because that's what it looked like. It was horrific. And to think of those two brave young ladies who got up during this trial to testify about what they saw, what they did, Jamie and Alyssa. Your dancers are proud of you, and because of you, justice has been served. We heard...
Okay, and I'm actually gonna back up really quick so we hear the full thing, but you don't understand the full gravity of the injuries that these people sustained until you hear the impact statements. And I was the same way. It was gruesome enough to the point where it would send chills down my back as we listened to them talk about it. But then when you actually hear the victim say, yeah, so I was in the hospital for months and this is the whole process of me getting better. Like, it's a lot. It's heartbreaking.
Justice has been served. We heard from others, spectators, Deborah Ramirez, brave young ladies who got up during this trial to testify about what they saw, what they did. Jamie and Alyssa. Your dancers are proud of you, and because of you, justice has been served. We heard from others, spectators, Deborah Ramirez, regarding herself and her son, that the vehicle was accelerating, not stopping. A moment that sticks out to me was really Mr. Brooks trying to chastise her for not seeking medical attention right away. Her response was perfect. She waited due to the number of injured and all the blood she saw. Understandable. Not something to be chastised for.
This is why I'm so glad she can speak now. I'm so glad that she can talk about this. I remember that part. I don't fully remember because there are so many people that he did chastise simply just for standing up to him and taking the stand. I mean, we know Darrell at this point, of course, he's not happy that somebody is opposing him for doing the wrong thing.
And then moving on, and again, I know I'm not mentioning everybody. These are just some of the highlights that, and I should call them lowlights, not highlights, but some of the testimony and evidence that really, really impacted the court. Stephanie Bonesteel and her husband testified about what Citizens Bank was doing, hearing the impact against Jane, a very loud thud and an audible gasp from the crowd. Her husband, Adam, was driving the support vehicle, and when he was being cross-examined about why he didn't see the driver, Again, he just simply said, I thought it was my wife that had been hit. All I saw was the red poncho. And the only time we ever heard about brake lights was when Jane Kulik was on that vehicle and he braked so he could get her off the top and run her over. We heard from Matthew Harris, who talked about the red SUV coming straight at them and then veering and going in the direction of the dancing grannies. And again, that audible gasp as he described that eerie sound. He saw a child injured in front, Jane Kulik behind. Actually, the child and Jane Kulik behind, and 2 victims ahead. He saw 2 of the dancing grannies. What he described as the SUV traveling faster than the speed limit. What I wrote down from his testimony is he's a combat vet, and this is what he said. I've never saw anything like this in such a safe area. You could tell he felt bad about not seeking treatment right away for his daughter. He talked about how his wife's a nurse practitioner. And again, he didn't want to direct resources from other victims, that we thought she was okay enough to be home with them. Now, by this time in the parade, it's very clear the spectators are noticing something is not right. The sounds, the atmosphere has changed. There's screaming, there's gasping. There's a noticeable difference. It's at this point, I believe, that Owen was struck, Kelsey was struck. Probably another miracle, given the injuries she sustained, the tear in her spleen, significant road rash cuts requiring facial surgery. What Mr. Knapp described the driver as having eyes completely wide open. And then next we heard from Laura Thien, one of the dancing grannies. She talked about the sisterhood. Another brave woman came in, talked about what happened to that group. 7 people injured from her group, 4 fatalities. She said it all happened in a matter of seconds. All I seen was bodies. It looked like a war. The 6 people who were killed suffered multiple blunt force traumatic injuries, severe, significant, some dying instantly. I was impressed by both Dr. Scheel and Dr. Bidzricki. Dr. Bidzricki for her attention to detail, her looking at that vehicle, inspecting it, looking at the heights where certain damage was done, and it being consistent in height with the individuals that she did the autopsies on. And of course, Dr. Scheel, and both of these individuals have testified before me, but Dr. Scheel, very shaken from the autopsy of little Jackson Sparks. We then, continuing on, heard from Father Witter, very gracious man. He too talked about how he noticed something unusual, saw an SUV flying down the road, heard thuds. It was faster than anyone in their right mind would be going. He estimated it to be over 25 miles per hour. And then Lucas Hallmark, the off-duty police officer who was walking with his family on that day. He talked about the commotion behind, the large amount of screaming. You could feel it was palpable when he testified about having the wherewithal to try to get his kids out of the way, throwing his 3-year-old as far as he could out of the way. You could see the pain on his face when he talked about not being that successful with his 7-year-old. He said, I wasn't quick enough. He testified that he thought this was a terrorist act, that SUV did not stop. I referenced the speed already. The ACE speed estimation from Detective Carpenter, 33 to 34 miles per hour, a little bit more than that. The speed calculation by Michael Smith from State Patrol from farther down the route of averaging 32 miles per hour. And then, of course, the vehicle inspection by the State Patrol, finding no mechanical issues. There was also the Franklin assistant chief who attended the parade. He was near West Main Street in Maple. He provided the testimony regarding the SUV, the window being open, and the driver sticking his head out, looking out. He testified how he thought perhaps it was either a medical emergency, maybe even a mechanical issue, but it was clear once that SUV passed him and he saw that driver. He saw you, Mr. Brooks. No panic, no distress. His heart sank. He knew it was not a medical emergency. The body language just didn't fit. It did not believe it was mechanical at that point either. And then he saw the vehicle crank to the right. As he testified, he seemed excited about what he had done. Another off-duty police officer, this one from Wauwatosa, talked about how he saw Mr. Brooks after the fact crash the vehicle, hear him yell out an expletive and run southbound with his sweatshirt still on. We all saw that video. Of course, at one point, Officer Skolton had contact. And as he testified, he put things together. Keep in mind all of the radio traffic, right, about one person, then like 15 people, and another 15. It was very apparent to him that although he was on the far end, he was around the dog leg on Wisconsin and Maine, that a vehicle had driven through the parade. He saw this vehicle. Of course, at that point, it was heavily damaged. He made the decision to use deadly force. What did he do after? What did Darrell Brooks do after? We crashed the vehicle. He fled the scene in a hurry. He changed his appearance, took off his sweatshirt, loses his shoes, I think in a hurry to get out of there, not caring that they had fallen off. He puts his hair up. We saw that on a number of videos. He asked unsuspecting people to use their phone to call an Uber. All within minutes of all of this happening. He was in such a hurry to get out of there, he left his phone in the SUV. He calls his mother, who arranges for an Uber. We heard from the Uber driver. He never showed up. It was nearby, ultimately, where he was found. And then, of course, the ring footage of his contact with Daniel Ryder. That is at 5:01 p.m. Minutes after all of this happened. Mr. Ryder was astute, noticing that after Mr. Brooks being in his home for maybe 8 to 9 minutes, he saw squads driving by. I think you could say his gut told him something wasn't right. And he had Mr. Brooks go onto the porch, of course, after having given him a sandwich, given him a coat to wear. Ultimately asks him for his coat back. And then, of course, the arrest.
And how about how crazy that is, right? Like, Daniel is an amazing guy. He took Darrell in, didn't have to, because he had no idea who he was. He's just a random guy. His act of kindness, it not only showed how good of a guy he was, but it held Darrell in place just long enough so the cops could get into that area. And then he kicked Darrell out. So it all worked out in the end. Because I'm sure Darrell would have gotten caught like very soon after that. But who knows how long he could have stayed out if he managed to evade them like in that area, because who knows, they could have combed through that area and decided, okay, he's not here now, let's move even further out. And by that point, Darrell has a chance to escape. So him being kind actually helped him out. And even the situation with the Uber driver wasn't able to find him, so he ended up leaving, but he stayed for an additional amount of time because he thought it may have been a kid. So it's like all of these people trying to do a good thing, Darrell still gets caught. Beautiful stuff.
This is where some of the lies become evident. Mr. Brooks claims ultimately when he's being interviewed by Detective Carpenter, they have to actually seek medical clearance for him because he claims that he was thrown to the ground when he was arrested. He was not. The video is very clear. He cooperated. He laid down. There was no use of force used at all to take him into custody. But we know ultimately that he lies about what he was doing in Waukesha, how he got there, who he was with. He lies about having contact with Erica Patterson the day before. We know when he's found, he has the Ford Key credit card, not only in his name, but one, whether it's a credit card or like a benefits card, but it's in the name of Erica Patterson, and of course an ID for himself, a state-issued ID.
So
the
stupid.
Ford itself is registered in his mom's name. It's the same address that's on his ID, and there was documentation found in the Ford Escape. He's now in custody. He's taken to the substation, ultimately taken to Waukesha Memorial Hospital. What's notable about the video and audio clips that this court reviewed from the hospital, Mr. Brooks is calm. He's coherent. There's no obvious signs of impairment, no obvious signs or really any signs of mental distress. He makes statements that he's not from the area. He doesn't appear disoriented or confused. At some point, there's kind of a jovial atmosphere between him and one of the detectives. The next day, he lies to Detective Carpenter, denies driving to Waukesha. I got a ride. He makes up the story about a tan Kia. He's very nondescript and vague with the information that he provides. And over the course of those 5 hours, he never once references the parade. He never once says there was another driver. Of course, they start talking to him initially about the domestic altercation because by that time it's very clear a link had been made between Erica Patterson and the call that police originally received of the domestic, or at least an altercation near Frame Park, and Mr. Brooks. We also know, because of the bond conditions in the 2 felony cases, he's not supposed to have any contact with her whatsoever. But he does. At no time during the 5 hours on November 22nd does he make any admissions. Does he show any concern for any of the victims? No empathy, only lies, only concern for himself, for his family. Can I have a phone call? He does not provide, and I said this already, the name of anyone else that could be driving that vehicle. At one point, Detective Carpenter says, one of 2 people drove through the Waukesha Christmas parade. Either a God-fearing person who screwed up or the malicious guy. Darrell Brooks' response is, don't spin it.
That's what you are. Like,
One of the things that has become abundantly clear throughout this trial, Darrell Brooks understands exactly what he's doing. His comprehension is fine. I have absolutely no concerns and have never had any concerns throughout this case and throughout this trial or even through the past day and a half regarding his competency. He's intelligent, he's deliberate, he's purposeful. He made nuanced arguments during this trial, one about the right to counsel versus the right to the assistance of counsel. That's a sophisticated legal argument, not the product of someone who doesn't understand. He asked questions on cross regarding tint, horns. He brought up the recall after the fact. He talked and asked questions about, question about barricades, police being at the intersection. Although we never fully understood what his defense was, what became very apparent to me as I reread through all of my notes is that from the very beginning, he wanted to argue jury nullification. If you go back to his opening statements,
very true.
He talked about power and the jury doing the right thing. He repeated that theme during his closing statement.
And thank you so much to everybody for telling me that, because I had no idea why he kept repeating that. I was like, why does he keep repeating, you have the power, you have the power? Do you really think the jury is going to let you go free? You've been a complete psycho this whole time, and for some reason they're going to say, yeah, that guy out of everyone deserves to go free. But another point I wanted to make. So the point that she made about Darrell making intelligent arguments. Now, Darrell is not intelligent by any means, but I do get what she's saying, which is that he tries to play the side of, oh, I have a mental illness and I just need help and this kind of thing. Then at the same time, as soon as the prosecution says something that he doesn't like, he wants to win against them. Trust me, if Darrell had the option of beating the prosecution in terms of his argument, he takes much more pride in winning in an argument than actually sticking to his role of, oh, I'm mentally ill. In the interrogations, oh, my arm is hurting, everything is so sore. But then he starts flailing his arms as soon as he gets into the story about Erica. Dude is an absolute clown.
At one point, he objected to evidence based upon a violation of one of the court's pretrial rulings. Again, a pretty sophisticated objection that resulted in the court striking an exhibit that had previously been received. Today, he spent close to 2 hours talking on his own behalf without any notes. He covered a variety of topics. I want to talk next about, here's my note that I found. One more thing on Mr. Brooks. You know, at times, right, we've seen the eye rolling, the fake clapping, the laughing, hand gestures, many times and most times very emotionless. Unless he's doing those things, which would be really inappropriate and are inappropriate, his reactions are largely negative when things are not going his way. What did this community suffer as a result of this tragedy, this malicious conduct by Mr. Brooks? Well, I think many of the victims who spoke said it best. Lori Locken described it as this: a sense of personal safety you robbed from us. I believe it was Bill Mitchell who said, the only life he seems to value is his own.
Very true.
Jason referred to it as evil.
Also very true.
And he talked about innocence being stolen. He called the defendant a coward. No remorse. What he said is, you look like a monster. You look disrespectful to court and witnesses. You look like a callous jerk. But I forgive you. Such character, such compassion. Margaret talked about the mental, physical, and emotional toll this has taken. She talked about how it was so traumatizing that her mind won't let her see everything that has happened, and that she's worried when her mind might allow her to do that. I'm thankful that she's 95% back to normal. She talked about emotionally every day, she's reminded of the physical pain and the loss of self. But she's had tremendous support from family and friends, and that today she will move on.
Nice. Beautiful stuff.
Jeff Rogers also commented on the lack of remorse and sympathy for the victims, how he has had to relive just the immenseness of this, the confusion, the anxiety, depression as a father, and irritation. He talked about how his son, Caden, was so concerned for his younger sister. I'm really glad Riley is okay. I believe that was from the day of the parade. And how he recognized he was inches away from losing 3 of his 4 kids just because of where they were located. He had flashbacks of grabbing his daughter's jacket, missing the first time, but that Riley gets up sometimes 6, 7, 8 times a night. How this was supposed to be a happy kickoff event for him as their new president, and how after it happened and in the aftermath, the weight of the moment, and 35 people there trying to find everyone, weighed on him. He talked about the media showing up at his door and the emotional toll things have taken. It was intense, and speaking at Jackson's funeral. He talked about how his faith is stronger. Again, very gracious, very inspiring. We heard next from Jessica and Juan, and how this impacted them, the loss of their son's friend Jackson. Their kids were involved in 2 different groups that day. One a dance group, not the extreme dance group, but a different one. And then of course the Blazers. And how, I believe it was Jessica who said, I yelled stop. I put my hands out as if I had the power. How she saw Jackson, and how she will forever have that image burned in her memory. And that she was so grateful when she found her son. How she covered his eyes to shield him from what was around. Not once, but twice they had to run, because at first it was what happened through the parade, and then the active shooter situation, because of obviously people didn't know who had fired the shots in that moment. And she talked about pain and terror. Many people talked about PTSD. I mean, for her, I was really struck by how difficult it has been because of what she saw, not able to be a teacher, how she's hypervigilant, and every sound sends her into a panic, how her joy has been stolen, and how she does her best to hold it together for her kids. But when she was alone, she cried, she screamed. And only a month ago was she able to return to work, but in a very different capacity. She commented on the lack of remorse by Mr. Brooks, and that he seems to search only for sympathy for himself. She said he will always be a danger to society. We heard from more individuals. From the Blazers, again, a lot of discussion of PTSD. the sights and sounds of the SUV plowing through, the impact to her and the kids, the nightmares, how parking lots are problems, there's panic attacks, that no one will ever be the same. Of course, we heard next from the Sparks family. They're hurt, angry, they're traumatized, they're broken. It was difficult to even watch them make their statements. Their hurt is palpable. She talked about her last hug with Jackson, the horrible sounds she heard. She saw a police officer holding Jackson. She went to Tucker, and that her world came crashing down. She talked about how she found a hat, both boys' hats, then shoes. Again, I didn't realize how significantly Tucker had been injured until she described that for us yesterday. How Tucker somehow blames himself for his brother's death. It's not your fault, Tucker. It's Mr. Brooks's fault. One of the things when there is a fatality with all of these victims is the future that is robbed from them, right? No future weddings, no future graduations, no future grandchildren or children, no plans. It's just gone. It's all memories. And the contrast,
I'm guessing he pledged to come back in.
the contrast with, frankly, what Mr. Brooks will have, and that is even a life in prison, he'll make memories, he'll have phone calls, he'll have visits.
Very true.
He may even get to hug the people that he loves again. For the 6 individuals who lost their lives, that will never, ever be a reality. And that this family also talked about the lack of empathy, lack of remorse, no apology. I'm aware Mr. Brooks wants to come back.
Please, no.
Says, I don't intend to interrupt in any way. That's not a pledge. He needs to pledge that he will not do so. I need that word in that statement. And if he does that, I'll bring him back in.
I don't even want to think about that. The idea that Darrell is actually in prison and he gets to like hug his mom or somebody that comes to see him. I know that they moved him. I'm hoping that amount of distance makes it to where it's just not even worth the trouble for somebody to go see him, because who's going to actually take time out of their day other than his mom and maybe that one lady that was on the call. I'm still baffled as to why she jumped on this Zoom call. But anyway, I never even thought about it. So I'm just going to take that thought out of my head right now. We're just going to keep going. I do not want to imagine him having an experience hugging a family member. Let's not do that.
I'm going to try to go a little bit faster. Some of the comments. The yells and screams from that night will haunt me for the rest of my life. I'm asking the court to give the max for each conviction because he has given the community a life sentence of these memories.
Very true.
I think it was Tyler's mom who talked about the community rising like a phoenix. You clearly have a phoenix for a son. He's strong. He got me a little bit with his comments. Wasn't expecting that. You're an amazing young man. You're a picture of resiliency, of fortitude, of strength. I think what this community needs. I thought it was quite a testament that you took those pictures and the same pictures of Jackson, you replicated that, and I thought that was a great tribute to him. You talked about, of course, rising up with Eric, who had significant injuries as well, both of you, and how you fought back and each were able to play baseball, even if not up to the full capacity that you had done previously. And then we next heard from Sasha, who's haunted by survivor guilt. My heart breaks for her. She talked about feeling empty, how she couldn't play soccer because her kicking leg would hurt from the injuries she sustained. She has difficulty sleeping, struggles with nightmares. Physically and emotionally, she feels stuck. She talked about maybe law school being in her future. And to her, I say, don't give him the satisfaction of holding you back. Rely on your friends and your family and be the phoenix that Tyler's mom spoke about. Jen Dunn read a statement from Sasha's mom, and I wrote this down. No one knows what it's like to stand on your feet when there is no floor. That's a pretty powerful image. I think that's very apt for what this community has gone through. We heard from others, including the Teagues. We saw photographs. So many families with more than one individual who was injured. How baseball for Eric was stolen, how he was such a good player. We heard a lot about night terrors and, again, PTSD and trauma. One of the individuals talked about humor is good medicine, and I would echo that. We heard about one band member whose instrument may have very well saved his life. Someone described it as a mental massacre, though, the aftermath of this. It's difficult to go downtown. It's difficult to get restful slumber. Panic attacks are common. Describe Mr. Brooks as sheer evil in its vilest form. I wrote down that despite all of the impact and carnage, many people talked about forgiveness, brokenness, sorrow, anger, hatred, regret. A lot of emotions. Frankly, really no emotion shown by Mr. Brooks, certainly not for what he did on November 21st. We saw a lot of anger for some of the people who lost loved ones, and understandably so. Many families were devastated. Nannies and grandmas were taken away. Yes, there were very specific terms used to describe Mr. Brooks, that in their opinion, he's a monster, he's a demon. Pure, unrepentant evil was one of the phrases that were used. Talked about the system failing us. Saw you in your SUV hanging out with a smile of satisfaction on your face. For one of Leanna Owen's sons, I lost my mom, and I wasn't always a good son. You can hear, right, the regret in that statement, because life is short, and these lives were taken far too short. We heard the very gracious statement from Michael Carlson, who, unbeknownst to me, had been writing Mr. Brooks in jail and sharing the gospel and the love of Jesus. He read a poem, which I thought was beautiful, from the standpoint of his sister. And he said this. In that poem, it says, "We both died that day. I, Tamara, died to life. You died to the world."
That was beautiful.
And then, of course, the Sorensen family talked next. They talked about never seeing their Grammy again. You murdered my mom. But at least I have some peace knowing she died doing something she loved. We heard from Brooke yesterday and today. She reread her statement due to the interruption. Proud of her for getting up here and sharing that. We talked about how compassionate each one of these individuals who died were. We heard about the compassion from Detective Casey that we learned about. It said Detective Casey came to our home to verify what we knew, and then he greeted us every day of this trial. They ended with, "Angels watch over us." 6 angels watching over us today. They asked me to hold Mr. Brooks accountable so that he will not have the opportunity to hurt anyone ever again. We heard from the Kulik family about the empty space that they have and the brokenness, their lives being shattered by mom and grandma being taken away. We heard from her youngest daughter among them. The grief was so palpable, being 17 and in high school as a senior, now a first year in college. She talked about all of the things she will never have with her mom. Just the last year alone, an 18th birthday for her and her brother, graduation, and beginning college. She lamented that her mom would never see her do her wedding vows, never see any kids that she would have, be a grandmother. She wouldn't be able to call her mom for parenting advice. And how excruciating it was for that family to wait 3 hours because of the chaos at the hospital. Talked about triggers of their PTSD, sirens, things of that nature. And how she waited. She waited hoping that Darrell Brooks would have a reason. She also said this, verdicts don't bring my mom back. No more hugs, no more dinners, no more talks. My mom was the glue that kept our family together, and we are falling apart. Moving on, Leanne talked about her safety and security being stolen by this defendant. She asked Mr. Brooks to picture his own daughter, unresponsive, lying on the ground with a leg injury, a head injury, and blood coming out of her mouth. She talked about the excruciating 2 weeks in the hospital, wondering if her daughter would ever live, in a wheelchair and then a walker for months. She said this, all you had to do was hit the brakes.
Literally all he had to do. Only thing he had to do was to actually stop. And I know I already said this, but we know the comment about if it was his own kid, it really wouldn't have made a difference to Darrell. I believe if Darrell's daughter was somewhere within that chaos and he knew it, he still would have done the same thing. I truly believe that. Oh, and I made the mistake of watching this without having any tissues around. Give me 1 second.
Her daughter talked about being scared of everything, worried about a sister, being alone in a church for 3 hours on lockdown because of what was happening in the aftermath. And we heard next from the Darrell family. A family that, of course, was impacted significantly with 4 of their children, all of their children being struck by the SUV. with the mom, of course, having to testify, in this case being called by Mr. Brooks, which, of course, was his right to call witnesses. But it's the manner in which, I think the indifference, not caring that this was someone who had 4 children impacted significantly. But clearly, you're raising your kids the right way. With grace and dignity, Charlotte got up and talked about the basic things you learned in kindergarten. She described what she saw as being stupid, delusional, and egotistical. She wanted to punch you in the face, and understandably so. I think her words were, "Your arrogance is pathetic," and her mom echoed those words. And then the gut-wrenching survivor guilt that you heard from her mom. She goes, "I say this with a heavy heart. I have my kids here. I had to fight for my children. They will strive." And then, of course, we heard from Alyssa, her heart-wrenching statement. She, of course, testified bravely, but you could tell the impact that this had on her and what she saw in the aftermath to the extreme dance team. How one of the girls, who at 10 years old, even lying on the ground being injured, had the wherewithal to ask, why would someone do this? If a 10-year-old knew this, then the defendant knew this. And how she left the hospital not knowing if she would see some of her girls again. She was completely and utterly broken, forever changed by this event. She waited. She talked about how she waited for remorse, for empathy. It didn't happen. Darrell said something very insightful yesterday, something we didn't hear about in the trial, but because of where he was at on the parade route, around the corner, waiting for his children. He didn't even know that all of them were in the parade. He said this, you hit the brakes to go around the corner. And then you drove through a barricade where an officer shot at you 3 times. Those brakes were working. You knew how to use them. And you selfishly only used them so as to not crash your own vehicle as you fled the scene. Talked about walking through and around that corner through the wake of carnage, bodies all over, women, adults, children deceased, people running all over. We heard from more of the members of the extreme dance team, either directly or parents and loved ones, how they had to walk through the carnage to find their children. Such a gracious statement of love, talking to Mr. Brooks about being a Christian and how she prays for him. Very powerful. Thank you for that. Her daughter, equally as powerful and brave and gracious. But even she knew, she said that I thought about you every day. How could someone do this? More victims talking about PTSD. How even the song that was playing during the extreme dance team performance is a trigger for her PTSD. And how she's forgiven him. We heard from the sister of victim HH and how the first thing she talked about was the sound of Vivian Darrell whimpering, crying, and then she found her sister, how her clothes were ripped off. She was unconscious, half naked. How she felt forgotten because her mom was at the hospital with her sister, of course, due to the severity of her injuries. How her sister was in a coma for 2 weeks. But how she has survivor guilt and issues like that, panic attacks, PTSD. She can't be around fireworks. Tires screeching is a trigger. That this turned her life upside down. And then, of course, we heard from victim HH herself. So brave to come here. I'm so very thankful you are recovering. Someone commented on how amazing it is to see the many people in recovery. You wouldn't know by looking at them, of course. The emotional and mental injuries are significant and severe, but so grateful. Frankly, lucky to be alive. I say to you, that scar on your neck should be a sign of strength and fortitude. You fought, you won. You have a story to tell. Don't shy away from it. Of course, we heard from her mother as well. We saw that PowerPoint with the pictures of their journey. The road rash on her face was horrific. You can only get a mental picture from words so much, but to see those actual pictures, her being intubated, and it's heart-wrenching. And all of the surgeries and the toll it took on their family. But she described her daughter as a warrior. I think all of you
absolutely
are warriors. We heard from Sam and her family and what she went through and how significant her injuries were. And her mom talked about the haunting vision she has of just what she saw because of her perspective. Sitting in the back of the pickup truck, she had a front row seat to horror. How she thought her daughter was dead because she was unresponsive, and blood, and really kind of the chaos and the confusion, and not really even being able to articulate what happened over the phone to her husband. She described what happened as careless and reckless. Asking Mr. Brooks, how could you do this? What kind of father does that? The last person we heard from was victim, I think it's Gigi, the mother of FF. If I have it reversed, please excuse me. And how I actually have her written statement that was provided earlier today, but how she was so taken aback by the conduct of Mr. Brooks that she
look at this absolute clown, dude. I wish the bailiffs would just snatch it out of his hand and push him back into the seat. Nobody wants to see you in the room. He literally just wants to come back to scream, to disrupt people talking about him. You're not that important. Sit in a chair.
Yesterday, because he was kind of motioning his hand like, okay, come on, let's get this over with, hurry up. She yelled at him, "You don't care." She goes, "You hit me. I saw you. You knew. You're a child killer. You're a woman killer." She was so flustered, she had to really gather herself before she could continue. So again, I want to thank the victims. I have other statements that I've read for people. So gracious. I think they were all members of the Catholic communities. Their statements were translated, very gracious, praying for Mr. Brooks. So I just want to you all to know that I've taken all of these statements into consideration today. I can't read your sign, Mr. Brooks. Can you hold it up closer? If it's a pledge that you will not interrupt me, I will bring you in for what will be the final section of my remarks today in the sentencing portion.
Judge, I think you should give him that opportunity before you go through the sentencing factors. And I can only read the top where it says objection, but.
Clown.
I can't tell what it is, what it says. He can bring the sign with. We'll clear the courtroom. We'll take a short break, and I will bring him back in. But I will warn you, Mr. Brooks, that there is one interruption. You will go back to that room because you will forfeit your right to be present for the sentencing portion. We'll be in recess until we can get him back in. Thank you.
This is not what I wanted to hear. It's the first time I disagree with the prosecution. He doesn't have a right to be here. I'm sure he does. I'm just making that up because I don't want him to be in there. But of course, he's coming back. Let's jump back over to the baby boy tantrum that is inevitable. Last little bit of his clown show. Let's get it started.
The record should reflect that it's 4:53. Mr. Brooks is back in this courtroom. Mr. Brooks, the only way I will honor that request is if you specifically waive your right to do so. Without that, that's not a convenience for you over there. It's you go over there when you frankly demand removal under Illinois versus Allen.
Didn't demand anything.
No, your conduct did. So
My
you can
conduct
sit.
didn't demand anything either.
Right, Mr. Brooks, please
keep
sit down.
Here we go.
And I'm going to continue with my sentencing remarks.
You keep changing the jurisdiction. Jurisdiction is a subject matter jurisdiction that has yet to be proven on the record. In
Mr.
that
Brooks?
court and in this one.
Please sit down.
I would like to go back to the other court.
It's not a courtesy to you. If you'd like to specifically waive your right to be physically present, then I will entertain that. Otherwise, you need to sit down.
I never waived the right to not be present.
That's because you forfeited your right to be present by conduct. You're now back in this courtroom.
Your Honor, I did what you asked me to do.
You never once pledged to me, sir, that you would not interrupt. And you're demonstrating by being here that you continue to interrupt.
Man, I ain't trying to hear all that because at the end of the day, I did what you asked me to do. You told the bailiff to tell me.
Mr. Brooks, this is not a debate.
You told the bailiff to tell me that I had to write.
It's not a debate. You asked to come over here, and I honored that,
well,
and I brought you back.
exercised my right 3 times. I shouldn't have had to do it 3 times.
None of those opportunities that you wrote to me said, I pledge to not interrupt.
I never had to do that before. You've never required that before.
That is actually not true, sir.
You've never required that before. Every single time that I've been brought over there, after some time, sometimes very short.
Who cares, you actual man-child? Can we get a last-second tackle from the bailiff? I see he's back there looking. He is waiting for that opportunity. He's refusing to sit down until he sees what happens here. Can we get a 4th quarter tackle from the bailiff right here? Because, that would be such a beautiful ending to all of this. Why does he think that we care 1%? He knows that we don't care. I'm not even going to pretend as if he thinks that. He literally just wants a reason to scream because his feelings are hurt that these people don't like him for hurting them. So only in Darrell's mind.
Sometimes an extended period of time.
You are just simply trying to delay the inevitable. Please sit down.
I don't care about the inevitable. It was already written from day one what was going to happen. It doesn't make me lose any sleep about that. I know I'm okay. I'm okay with everything.
Then please sit down.
I just want to be treated fairly, which I have not been.
Please sit down.
And then Your Honor, always make it seem
this is
like
not a
you always
debate.
make it seem like it's some type of aim, and it's not.
Please sit down.
We're talking about constitutional rights. You just told me, or you told the bailiff to tell me that I had to exercise a right that I should already have. I did that. Not once, not twice, 3 times. And it still wasn't honored. And then I raised this sign. I'm waving this for like 20 minutes, saying I would want to come back. I'm doing this.
You're here now.
Can I come back? Can I come back?
Sit down.
It wasn't honored. And then I said, okay,
finish.
I'll write this and I'll see if Your Honor can see it on the screen. The objection sign saying, I've exercised my right to be present.
If you stop for a minute,
may I have the order of the court?
I'll explain it, but you have to stop so I can explain it.
Your Honor,
The cell doors are closing on Darrell. Those cell doors are closing a little too fast, aren't they, bud? You gotta scream a little bit louder. Then maybe those cells, it'll open up a little wider. I'm sure that's what he thinks it's gonna be.
Actually not.
Yes.
Let me explain
And
if you would like.
If I didn't, Your Honor, if I did not do what you asked me to do, then why was I allowed to come back if I did not do what you asked me to do?
Because I'm frankly going to a very distinct portion of this hearing where I am going to impose sentence.
Okay, that doesn't
and
answer the question, though.
matters.
That doesn't answer the question.
Please sit down and I will
Answers the
explain
question.
and
Your Honor,
remain quiet
with all
without
due-
interrupting me.
With all due respect.
That doesn't mean you're respecting me, so please sit down.
With all due respect, you told the bailiff, when I first said, because every time that I've been brought over there in the past,
Mr. Brooks,
you always stated,
I don't need a history
you always
lesson of
stated
what I've done.
that when I exercise my right to be present,
Untrue.
you've
Untrue.
always said,
Untrue.
we have the record. We have the record. We can dig into the record.
Mr. Brooks?
I know what the requirement was of me going over there. You've always stated on the record that when I exercise my right to be present, you will bring me back if I will follow the rules of decorum. That's your exact words, which you said every time.
Which you're
I've
demonstrating
never
right now that you
had-
have absolutely
Your
no
Honor,
ability to do.
With all due respect, I've never had to go through any type of certain words that needed to be said or stressed or anything like that before. I've always done it the way that you've asked me to do it. No different than today when I
So what do you want to resolve this issue, Darrell? Do you want that box of Kleenex from the other room? Can we get the bailiff to bring the box of Kleenex in here? Is that what he's asking for? Maybe this whole time Darrell just wanted a shoulder to cry on. What's the resolution to this little tantrum? I'm hoping it's you getting tackled. That's what I want the resolution to be of this little situation. But no, just scream more.
told the bailiff I would like to be present. You told the bailiff if he wants to be present, he has to put it in writing.
And pledge to me that he will not interrupt me
I put it in writing.
without a pledge.
So why am I here?
Can we kick him
Because
out?
I'm going to move on to another phase of this hearing, and I thought it important that you be here in person.
So I was here.
But you didn't reclaim your right to be back here.
Then why am I here
am
then, Your Honor?
allowing it to
Okay,
happen.
and I respect that you're allowing it, but still, it doesn't answer the question, though, Your Honor. It does not answer the question.
Mr. Brooks.
Your Honor, as a public
Brooks.
servant, I have the right to ask questions
Sir?
of Your Honor.
I'm going to ask you one more time, and if you refuse to sit down,
No
then
more
you are
asking.
in direct disobedience
Only
of a court
tackling.
order. Sit
That-
down and be quiet so I can make the appropriate record.
Can you tell me what the
All
court
right,
order
he's
is?
not going to obey. He's now
I
forfeited
didn't
his
say
right
I
to be
wasn't gonna
present.
obey.
He will go into the
I
other
didn't say I
courtroom.
wasn't going to obey.
We'll
I
be in
just
recess
asked what is the
until he's
order.
there.
I just asked what is the order. I didn't.
Oh, I was hoping that bailiff was right there. Look, after everything that we've seen, we know that this is the only trick up his sleeve. And of course, him saying, I don't care, I'm okay with the inevitable. Darrell's finally being real, everybody. And for that exact reason, we don't care about this 1,000 years that you're about to serve, bud. Let's go ahead and get to that moment. I gotta get my confetti popper, which I keep misplacing. This is still a celebration. Darrell is going away forever. Let's not forget that. He's trying to make us forget, but it won't happen. Let's go ahead and skip over to Darrell's big day. He looks absolutely ridiculous. I wonder why he put the mask back on. I guess it's because his mom is gone, so no point to have it on.
Thank you, please be
off
seated.
Anymore.
Of course, I do need to first verify that they can hear and see us. I'm getting the thumbs up. We are back on the record. The record should reflect that Mr. Brooks is no longer in the main courtroom. He is in the adjoining courtroom. I, of course, have been erring on the side of constitutional caution, but I would note that his right to be present at sentencing is a statutory right, which, frankly, I probably don't need to go through the findings under Illinois versus Allen, but I did. But under whether it's a statutory right or a constitutional right, you can forfeit that right, and his behavior today has certainly demonstrated that he has forfeited his right to be present in this courtroom. During my sentencing remarks, he immediately came in I was on the bench looking through my paperwork. The courtroom wasn't even open, and he started asking me questions. I said I wasn't going to answer them. He really had no respect for the proper decorum. I needed it to be on the record. He didn't seem to care about that. Wanted to debate me about my prior rulings. Bottom line is, it's a statutory right for him to be present, and he's forfeited that right. And I would just add that it's part of a pattern that has been demonstrated during this trial, that when my perspective, things are not going in his direction, things are being said that he doesn't agree with, that he tends to act out, he disrupts, and I'll leave it at that.
He looks absolutely ridiculous.
Once again, I'll
right
confirm
now.
he can hear and see. We've got confirmation from the staff in the other courtroom. One of the reasons I really spent the time going through both my observations of Mr. Brooks in terms of the mental health related issues, and first, and then going through the victim impact statements before I go through all of the necessary factors for sentencing, is frankly, it's challenging to talk about the impact to the victims without getting emotional. This trial is unlike anything that I've ever been a part of. The sheer magnitude of the crime, the number of people impacted, how they were impacted, the vicious, senseless nature of it, and hearing about the impact of all of that on our community members and the people who are at the parade, it's heart-wrenching. And I wanted to do that before I really got to the meat of sentencing, because I also thought it was important to really spend some time recognizing and acknowledging the impact to the direct victims who are in this courtroom and who have provided statements. Today, my focus in sentencing will be about November 21 of 2021, the events shortly before that or leading up to it and after, and are not about Mr. Brooks's conduct during this trial, even though case law is very clear that his conduct at trial can and is a legitimate factor for the court to consider.
Oh, I wish so badly that was included, but okay.
I need to make the record very clear that in no way what I do here today is based on Mr. Brooks exercising his right to a trial. That is a firmly embedded constitutional right, which I support, which I upheld. Of course, every person charged with a crime has a right to a trial. This court honored that right. I protected that right, even if Mr. Brooks treated it with contempt, disrespect, and at times like a game. But sentencing today is directly related to his conduct on November 21 of 2021 and the other sentencing factors, which, as I indicated previously, include the seriousness of the offense, the need to protect the public, and his character and rehabilitative needs.
Why does he think we care about his little sign?
Today, I am tasked with sentencing Darrell Brooks for 76 counts related to a couple of moments in time. Moments that are tragic, moments that were frankly avoidable. My sentence here today is, the purposes of it are twofold, really threefold if we think about the community. One, it is punishment. 2, protection of the community. And 3, what I hope is justice and closure for the families and the community at large. I, of course, want to recognize and give due respect to the guilty verdicts that were rendered by the jury in this case. Not just 76 guilty verdicts, but the special verdict questions that they answered, including for counts 1 through 6 and 7 through 67 that had the special verdict question related to the use of a dangerous weapon. So let me talk about the seriousness of this offense. The seriousness of the offense can be summed up, frankly, in one word, and that is attack. There is nothing, no other word that can best describe what happened on November 21 of 2021 than the word attack. I talked about during my remarks regarding the trial about the opportunities that Darrell Brooks had to avoid this altogether. I put Exhibit 15 on the screen for a bit, which is the exhibit that details the map. The map of the parade. It starts with White Rock. It shows where Sergeant Warner was at one point, farther up that parade route, the staging area, and I believe if you look further up on Exhibit 15, it even depicts where White Rock School is, and that, of course, is where we saw the video of the altercation between Mr. Brooks, Corey Runkle, Nicholas Kirby, and Erica Patterson. Now, of course, there were moments in time before that, but that is really where things started, where I believe Mr. Brooks boiled over with rage and anger that he chose not to control on this date. He had a number of opportunities to simply drive in the other direction down White Rock, but he chose to drive toward Main Street, even though from the testimony we know it was very evident that it was staging for a parade. There were many people, may not have been exactly by the school, but farther down White Rock. From Niagara forward is where that staging area was located, and many people were there. The sights and sounds of a parade, the signs on the side of the road telling people not to park there, for example.
Okay, really quick. I'm so glad that she just summed it up as an attack. I was so sure that they were going to flip the camera back over to Darrell and he was going to be freaking out in the other courtroom, but I think at this point he's fully given up. But this is like a last second glimpse into Darrell's entire mentality. Like she said, you could see the signs as you're going down that direction, but his mentality is, I don't care. They need to just get out of my way. You know, that was his entire thought process when it came to going that direction, was that everyone that's in the way just needs to move. I don't care that it's a parade. I'm coming through and I'm Darrell Brooks. For whatever reason, I'm more important than all of this.
Instead of turning around, or instead of turning left onto East Main Street or left onto Pleasant, and despite Sergeant Warner trying to flag him down and being in front of a squad with lights, and a clear indication you should listen to or honor the even gestures of a police officer, and he was in uniform. He drives down White Rock Avenue and has contact with Detective Casey, who very clearly did everything he could to stop Mr. Brooks. And in that moment, thinking it's a lost motorist. But Mr. Brooks chose to basically brush him aside with that SUV and drive on to Main Street. Past more people, past many spectators, and in a manner that was not just at a speed inappropriate for a parade, but frankly, that was reckless and endangered anyone who was on the roadway at that time, whether or not he hit anyone between White Rock and Main and Barstow and Main. But during that 3-block section of Main Street, he could have turned off Buckley, Northeast Avenue, Martin Street, or in either direction on Barstow. He could have stopped, asked for the police barricades to have been removed, or frankly turned his car around even at that point and gone back the way that he had come. But he didn't do that. He chose to drive recklessly, carelessly, and maliciously through a parade route and at anyone in his path, where he struck not one, not two, not three, but 68 different people. We actually know that number's higher because we now know, we heard from the two individuals who were with Extreme Dance, the one girl who was struck by one of the individuals who was clearly struck, and that person flew into her. That would qualify for a charge based upon the state's description of how they chose to charge. It's just they didn't know until closer to the sentencing hearing. So 69 individuals if you include her. There are so many aggravating factors here, it's frankly difficult to even keep track of them all. The complete disregard for the lives of anyone else that day. Someone described it as depraved indifference, and I think that is the perfect phrase to capture the actions of Mr. Brooks on November 21st of 2021. The aggravated factors of the numerous opportunities to turn around or not even enter the parade route or simply to stop. The fact that he mowed over and used that vehicle as a battering ram to hit 68 individuals, never once stopping, with rage and anger at unsuspecting people at a parade who were there simply to kick off the holiday season, to experience joy with their families. The intentionality of the conduct is outstanding. The viciousness, the speed, the swerving from side to side at various points. This was not a case of whodunit. From the very beginning, from when this case was charged, it was clear who did this. Now, that is not to say that I prejudged this case. I did not. But after sitting through this trial, after watching the many videos, after listening to the testimony of the many, many dozens of witnesses, it is clear the state had overwhelming evidence of Mr. Brooks's guilt.
Very true. And I'm not going to lie, at the very beginning of this trial, before we even got into any evidence, as soon as I saw the way he was acting, I pretty much knew we had the right person. I'm just saying, as soon as I saw that, I was like, okay, he probably did it. But I get what she means. You have to review the evidence first.
What's also aggravated is his complete and utter lack of remorse. He spoke here today for 2 hours. One sentence, that's it. I'm sorry. No detail. 2 hours, 1 sentence. No empathy for any of these individuals.
Uh-oh. I think that's just the live feed doing that. Okay.
At times mocking them with hand gestures or rolling his eyes multiple times. That is not an indication or a sign of someone who has empathy, who is sorry for what he has done. We may never know the true why, but we were provided with nothing here today other than a feeble attempt to blame mental health.
I am so happy he's speaking. I'm sorry I'm pausing so frequently right now. It's just we're at the end of the trial, so I'm not going to have like another, I mean, I could do like a follow-up video, but since we're at the end, I just want to go ahead and say certain things now. I'm just glad that she's saying this right now to his face to tell him, you are an absolute idiot and nothing that you did here worked. And not only that, you showed no empathy and you making this decision that much easier. I'm so happy that we're having a little moment like this, and he's sitting here like an idiot thinking that any of us care about what this little piece of paper says on it. It should just say, please give me the 1,000 years that I deserve. I can't even read that. I have no idea what it says. The clown show ends here.
Which frankly does a disservice to those who truly suffer from mental health issues.
Absolutely.
I understand why his family might cling to that, because of the difficulty in coming to grips with a loved one doing such heinous things. But for Mr. Brooks, it's nothing more than indifference, deflection, and outright denial of what he did and the impact that he has caused as a result of his heinous actions. I searched for a mitigating factor in this case. I waited patiently for an apology, a true apology. I didn't get it. And not for my benefit, but for the victims.
Right.
The law allows me to look at things such as Mr. Brooks's prior criminal history, including the history of criminal offenses and pending charges, the history of undesirable behavior patterns, which can include dismissed, uncharged, or unproven offenses or facts, even including expunged offenses not really relevant here, acts resulting in probation revocation. Of course, those are part of his criminal history, nothing specific to these charges. I can look at his personality, character, and social traits, the vicious or aggravated nature of the crimes, the degree of his culpability, his demeanor at trial and truthfulness, his age, his educational background and employment record, his remorse, repentance, and cooperativeness, his need for close rehabilitative control, the rights of the public, the recommendations of the interested parties, including victims and family members of homicide victims. I can consider statements made by his own family. I can certainly consider the length of pretrial detention, which I'd note, though, when facing 6 life sentences, is really a fraction of the time available to this court. The loss of life in this case is certainly one of the aggravating factors here today. The number of people injured also an aggravating factor. The reach into the community, certainly palpable, because this was a Christmas parade. I think it was a comment earlier, either today or yesterday, that this was not like one act where Mr. Brooks drove into a crowd of people. This was sustained driving from block to block to block to block, picking off people that were unsuspecting. 68, 69 times. Driving over people as if they were nothing more than speed bumps. What's also aggravated is his conduct after he drove through the parade. Crashing his vehicle in an attempt to flee. It's pretty evident based upon the evidence and testimony from trial that Mr. Brooks had no idea there were these logs in that backyard that could damage his vehicle. He was attempting to flee when he ran over them, and it ultimately disabled that vehicle.
So glad it did.
And he was forced to abandon it. He ditched it, leaving personal identification information in it and his phone in a clear attempt to get out of there in a hurry. And then we have that series of videos that we saw at trial of him going through backyards, coming in contact with people, asking to use phones, ultimately ending up at Mr. Ryder's home, who graciously took him in. Never once, Mr. Brooks showing any signs of distress, of any emotion of what he had just done. Cool, calm, collected. Certainly not a sign of someone who had any remorse for what he had just done. Someone who's involved in an accident, even a tragic accident, one where they flee the scene and are later caught, oftentimes show incredible remorse, tears. Not tears for themselves, but tears for what they've caused. A recognition of the loss of life, for example, from their conduct. Nothing. An individual who simply wanted to flee. That is the epitome of consciousness of guilt evidence. Fleeing, changing your appearance, taking off the sweatshirt, not even caring that your shoes are off your feet because you're so intent on fleeing the area. Putting your hair up from it being down. No doubt, this is by far and away one of the most aggravated cases I've ever presided over. The sheer magnitude of the loss, the number of victims, the types of crimes for which the jury has convicted him. 6 counts of intentional homicide, 61 counts of first-degree recklessly endangering safety, 6 counts of hit and run, 2 counts of felony bail jumping, 1 count of misdemeanor battery. What's further aggravated is the fact that he was out on bond. He should have had no contact with Erica Patterson. But the rules mean nothing to Mr. Brooks. Nothing.
Very true.
He didn't care. This was someone who on two prior occasions charged with, frankly, causing mayhem. One, a reckless endangering safety for discharging a firearm. The other for battering and then running over Erica Patterson's foot. This court does get to consider the other act's evidence that the state sought to introduce at trial. That other act's evidence includes that on November 2 of 2021, Milwaukee police took a complaint from Erica Patterson that Mr. Brooks had run over her with his vehicle and tried to kill her. She had tire marks on her right pant leg. She could not move her leg and had blood coming from her mouth. On that date, Mr. Brooks was driving the same vehicle that he drove through the parade. Erica Patterson was conveyed to Frederick Memorial Hospital. Her injuries received medical attention. She even had that boot on her leg on November 21 of 2021. She described Mr. Brooks to police as yelling at her, using profanity, as she tried walking past him when she was at a gas station. I think initially before that, at another location, but ultimately where he allegedly ran over her was at a gas station and caused the injury to her leg. Struck her in the face once with a closed fist, causing pain and bleeding without her consent. And then it was after she walked away that he followed her.
What a coward. The most cowardly human being. You see how he checks every single box. Everything horrible that you could be wrapped up in one individual. This is known. I didn't even need to say it.
When police had contact with him, he denied driving his mother's vehicle. When police had contact with him at his house, he ignored their commands because he was found in the vehicle, claiming that he was having an anxiety attack upon the sight of the squad car and needed to get into the home to get his inhaler. When I say the rules don't matter to Mr. Brooks and court orders mean nothing, Mr. Brooks was in custody, and there are jail phone calls where he's berating Erica Patterson, encouraging her to recant.
I heard about this.
Blaming her for what had happened. Saying things on that phone call like, you trying to make it seem like everything is always everyone else's fault but yours. Like you don't never do anything to cause shit. And the whole cause of this shit was something that you fucking did. He ended the call by telling Erica Patterson, you did this shit and you couldn't even keep your mouth shut after numerous people told you that shit. This ain't the place for you to be doing this shit. And you still ran your mouth. And I'm the one sitting in here facing all this time. Repeatedly calls her a bitch. During a phone call on November 11th, Darrell Brooks is overheard or captured saying, why in the hell would I just try to mow her down knowing I could kill her like that? Like, okay, I probably got a few screws loose, but I ain't hardly no goddamn fool.
Darrell, I hope you're somebody's personal punching bag. I hope you are. I hope you're a personal punching bag in prison. This is really him. And I specifically remember people in the comment section telling me that this happened. I had no idea that we were going to actually hear what he said through Judge Darrell. And this is more of like a tangible way of, I don't even know if I'm using that word right. Like when you're actually physically hearing the words that he said is infuriating. Hopefully Erica is somewhere with her feet kicked up, having a good time. Hope her leg is all healed up. Hopefully Darrell's is broken right now.
He's complaining that she won't help post his bail. You didn't put a cent on my bail. Why should someone else have to pay for some shit you caused? The end, apparently, of that conversation, or at least moments later, he says to her, nah, I didn't try to do anything, because if I tried to do something, you wouldn't be on the phone now. That's what you're not realizing. If I really tried to do something, you wouldn't be on the phone now. That is the rage and the anger that Mr. Brooks had on November 21 of 2021 when he tracked down Erica Patterson, confronted her. This wasn't about him getting money from her, like he lied to Detective Carpenter about. This was to confront her. He clearly hit her, we know that. This is the type of man that drove through the Christmas parade, enraged because, frankly, it's entirely possible that Corey Runkle and Nicholas Kirby saved the life of Erica Patterson. True. It's clear Mr. Brooks was hell-bent to cause harm to her, but she was able to get free, run back to her friends. Who knows what would have happened but for their intervention. If you think back to the testimony of Nicholas Kirby, he felt bad for threatening Mr. Brooks, like somehow this was his fault. He was just trying to be there for his friend, someone he recently met. So, Mr. Brooks, that other act's evidence is a very clear indication of your poor moral character. It demonstrates unequivocally that you have absolutely no remorse for anything that you do. You have no empathy for anyone, and that you are justified in the actions that you take. In addition to that conduct, as part of your character, this court is able to look at and consider your prior record. And I'm well aware, sir, that you're raising an objection sign, but you have forfeited your right to be here, and I will not stop, and you will not be brought into this courtroom. I will continue. This is his prior record.
Nice.
Going back to two thousand, spanning what? Nevada, Georgia, at least police contact in Georgia. We have an unknown disposition in Wisconsin.
Everywhere he went.
Substantial battery in 2000, party to a crime. Put on probation, ultimately that was revoked, he went to prison. 2002, felony possession of THC, jail time. 2003, resisting obstructing, jail time. 2005, a disorderly conduct ticket, but he failed to pay the forfeiture and ended up serving an alternative to incarceration. He ended up serving for failing to pay 30 days jail. 2009, obstructing, 2 days jail, meaning he lied to police.
Surprise.
2010, strangulation. Battery was dismissed and read in, put on probation, ultimately revoked, serving 11 months jail. 2012, misdemeanor bail jumping, possession of THC, with a number of other charges being dismissed and read in, 180 days jail concurrent. Also in 2012, a misdemeanor resisting or obstructing. So either he lied or he fled from police or did something to make their job more difficult. 37 days jail consecutive. In Nevada in 2006, domestic battery, a suspended sentence. Obstructing after being found guilty at trial, for which he served jail time. 2007, statutory sexual seduction as a felony. This is for impregnating Erica Patterson when she was a minor. 2016, charged with not being in compliance with the sex offender registry requirements, for which there is an outstanding warrant. In Georgia, a 2021 arrest for battery, domestic violence, presumably with Erica Patterson based upon where she came from at that time. But I won't make, I say presumably, but frankly doesn't matter who it was with. We also know that there's the 2003 paternity case out of Waukesha County. Why is that relevant? Because 8 times during that case, a warrant has been issued for contempt of court, meaning for failure to pay his financial obligations to a child or children.
Not a surprise at all.
The pending cases for which one pending case, I should say, he was, I don't believe, charged with bail jumping for that one. The 20 CF 2550, 2 counts of recklessly using a weapon, felon in possession of a firearm, released ultimately in March of 2021. He's accused in that case of firing a shot. There were two occupants in a vehicle. One was his nephew, and when he was picked up by police, a loaded Beretta, 9mm, which had previously been reported as stolen, was found in his possession. I already talked about the other acts evidence, that is the for which he was charged with felony bail jumping, the second-degree recklessly endangering safety for allegedly running over Erica Patterson, the battery DV, DC DV, and a resisting obstructing. And then the second would be those he was charged with intimidation of a victim, felony bail jumping for conduct on November 8th. So November 2nd, November 8th. This is clearly someone with a demonstrated violent history and past. Someone who has absolutely no regard for anyone but himself. To say that he is a lifelong criminal, I think, is accurate. He disobeys law enforcement, he disrespects court orders, and he certainly demonstrated that he has no respect for these proceedings. Multiple acts of violence, violent, dangerous behavior that predated the attack on the Waukesha Christmas parade. His character, or lack thereof, is also demonstrated by his complete and utter denial of culpability in this case. His blaming of his mental health or alleged mental health. There's no evidence that he was suffering from a manic episode. I went through all of that earlier today, going through the 4 reports related to the special plea. None of those doctors found support for his special plea. Mr. Brooks talked about, at times, this being the will of God, or that all things happen for a reason. I'm here to tell you, Mr. Brooks, you are not an instrumentality of God. Death may be inevitable to all of us, But you cut the lives of 6 individuals short. You alone, Mr. Brooks, cut the lives of these 6 innocent people short. I talked earlier about how I believe he's intelligent, deliberate, and purposeful in what he does. I've considered that you have treatment needs. Perhaps there are intersecting mental health issues as it relates to your personality disorder, but those issues can best be addressed in a confined setting where the Department of Corrections will be charged statutorily to evaluate you and to provide any medical or mental health treatment that you need. This is a case that falls squarely on the need to protect the community. I referenced this earlier. There's really 3 primary reasons for the sentences I will impose here today. One is punishment, one is to protect the community, and the other is to provide justice and closure to the victims. Because under that category of need to protect, the court does get to consider the impact of these crimes on the victims. I went through at length in reviewing all of those victim impact statements. I certainly didn't go through every single one, just highlighting some of them, but doing so with purpose, because it is very clear to this court that Mr. Brooks has caused carnage, mayhem. It has resulted in many people suffering from PTSD, from mental and emotional trauma that will take a lifetime to recover from, and for some, perhaps, if at all. You have taken away from these individuals future memories. They will never have birthdays with the 6 individuals who were killed. There will be no weddings. There will be no graduations. There will be none of the milestones that these families were looking forward to, whether it be for an innocent 8-year-old or an innocent 79-year-old. Frankly, Mr. Brooks, no one is safe from you. This community can only be safe if you are behind bars for the rest of your life. The actions of Darrell Brooks demand punishment. The community is not safe from your violent and criminal conduct unless you are in custody. You left a path of destruction, chaos, death, injury, confusion, and panic as you drove 7 or so blocks through the Christmas parade, never once stopping or seemingly caring about the wake of carnage that you left. 4 of those blocks were turned into a scene that frankly is no different than a war zone. On counts 1 through 6, this court is imposing a life sentence without the possibility or eligibility for extended supervision consecutive to one another. 1 life sentence for Virginia Sorensen.
I'm gonna wait till she does them all.
1 life sentence for Leanna Owen. 1 life sentence for Tamara Durand. 1 life sentence for Jane Kulik. 1 life sentence for Bill Hospel. And 1 life sentence for Jackson Sparks. I've considered the enhancer and the additional 5 years that I could impose, but I don't need to really order that because I've not made him eligible for extended supervision, and it would only be to increase his time on initial confinement. But make no mistake, Mr. Brooks, you use that vehicle as a battering ram, no different than, frankly, a firearm. On counts 7 through 67, these are 61 counts of first-degree recklessly endangering safety. These charges alone and these convictions without the enhancer carry a maximum of 12.5 years. Because of the enhancer.
I'm so happy. I don't know if I should go ahead and let the confetti popper go right now. I'm going to let her do this whole thing. We'll do it like that. She's going to read off every one of the charges, and then we'll do it.
17.5 years. And under Wisconsin law, the 5 years is added to the initial term of confinement. So what could be 7.5 years is a maximum of 12.5 years. And I'd ask that everyone no longer show any reaction to the sentence so I can get through this. On counts 7 through 67, on each count, I will impose a total sentence of 17.5 years. 12.5 years of initial confinement, plus 5 years of extended supervision, consecutive to any other sentence that I've imposed here today. That is 762.5 years of initial confinement and 305 years of extended supervision on top of the life sentences that I've imposed. That is 17.5 years, sir, for Nicole White. 17.5 years for Eleanor Andrews.
Let's get a screenshot. Darrell, why are you not celebrating with us, Darrell? This is your big day, bud. Come on, we're celebrating. Pick up the Bible. Let's get this going. And now your life is truly getting started. In a prison, you absolute monster, you.
Anders, excuse me.
Oh, man, I'm so happy. Okay.
17.5 years for Sasha Catalan Castillo. 17.5 years for Maura Gilchrist. 17.5 years for Justin Gullickson. 17.5 years for Harry Guilfoy. 17.5 years for Aiden Lofgren. 17.5 years for Theo Maza. 17.5 years for Tyler Hudliner. 17.5 years for Connor Tank. 17.5 years for Eric Teagues. 17.5 years for Adelia Maffioli. 17.5 years for Kelly Graybow. 17.5 years for Josh Craner. 17.5 years for Riley Rogers. 17.5 years for Caden Rogers. 17.5 years for Tucker Sparks. 17.5 years for Isabella Bartlett. 17.5 years for Yaritzi Becerra Montez. 17.5 years for Samantha Coelho. 17.5 years for Madison Hollingsworth. 17.5 years for Mackenzie Hollingsworth. 17.5 years for Mitchell Lampine. 17.5 years for Kathleen Pielmeyer. 17.5 years for Julia Schleichow. 17.5 years for Olivia Stover. 17.5 years for Jennifer Stover. 17.5 years for Jesselyn Torres. 17.5 years for Alice Urell. 17.5 years for Charlotte Urell. 17.5 years for Vivian Urell. 17.5 years for Grayson Urell. 17.5 years for Lola Hospel. 17.5 years for Tamara Rosentreter. 17.5 years for Betty Strang. 17.5 years for Maria Alvarez Dominguez. 17.5 years for Gregoria Romelia Perez. 17.5 years for Elliot Hallmark. 17.5 years for Benjamin Hallmark. 17.5 years for Patrick Heppy. 17.5 years for Lori Locken. 17.5 years for Marisol Lopez Gutierrez. 17.5 years for Adair Lopez Rubelar. 17.5 years for Juan Marquez. 17.5 years for David Marquez. 17.5 years for William Mitchell. 17.5 years for Jason Petchloff. 17.5 years for Margaret Pachulis. 17.5 years for Yamilet Perales Alvarez. 17.5 years for Aylan Perales Alvarez. 17.5 years for Ashley Perales Alvarez. 17.5 years for Jose Perales Alvarez. 17.5 years for Maria Perez. 17.5 years for Camila Perez Gonzalez. 17.5 years for Isaac Foglia. 17.5 years for Deborah Ramirez. 17.5 years for Charles Green. 17.5 years for Lily Green. 17.5 years for Brinley Harris. 17.5 years for Kelsey Knapp. 17.5 years for Owen Ricciati. On counts 68 through 73, which are the 6 counts of hit and run resulting in death, these are 25-year felonies each. The court will do the following. On count 68, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision. This will be concurrent to count 1. Count 69, the same sentence, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 2. Did I say that the right way, the first one? Okay. Count 68 is concurrent to count 1. Count 69 is concurrent to count 2. Count 70, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 3. Count 71, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 4. Count 72, 25-year total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 5. And on count 73, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 6. On count 74 and 75, the 2 felony counts of bail jumping, the court is ordering a 6-year sentence total on each count, 3 years of initial confinement, 3 years of extended supervision, consecutive to all other counts but concurrent with one another. And lastly, but certainly not least, the maximum sentence for the battery to Erica Patterson, 9 months consecutive to any other sentence. To order anything other than what I have done, sir, would be to unduly depreciate the seriousness of these offenses. It is needed, although largely symbolic, given the number of years that I have imposed here today, because frankly, you deserve it. I know it's symbolic, but it needs to hold you accountable in a very real and tangible way. For all of these sentences that I have imposed, I will order the following conditions: no contact with the victims as identified in the amended victim key or their family. Okay, that was a bit nerve-wracking there at the end. I don't know if you all saw that. That sentence alone, you deserve it. You earned every single minute of this, Darrell. This trial wrapped up so long ago, but this made my week right here. This is amazing. No contact of any kind with Erica Patterson. You are to pay restitution in the amount of $47,193.29 to EMC Insurance Company, that's on behalf of the Waukesha School District, and $124,000, $220.65 to the Crime Victim Compensation Program. I'm ordering DNA surcharges on all counts. On counts 1 through 75, it's $250. On count 76, it's $200. Those are mandatory under the law. I'm also imposing the domestic abuse surcharge on count 76 of $100. I'm also imposing all standard court costs on all counts. Although my primary emphasis is that restitution be paid before costs, surcharges, and fees, I will order that restitution, costs, and fees be paid out of prison money. In other words, that all financial obligations shall be collected pursuant to statutory provisions as requested by the state. That's frankly a standard, it's customary, but it will be in the judgment of conviction. And then pursuant to 949.165, I'll find that it is appropriate for this court to order an escrow account under 949.165 for payment of restitution, costs, fees, surcharges, and even for costs associated with prior legal representation or future representation under the statute. Mr. Brooks has been convicted of a number of serious crimes for which this section is appropriate. I will order 360 days credit as to count 1 and count 68. Only, all other counts, 0 days credit because of the consecutive nature of the sentences that I've imposed here today. I calculated that with my sentence calculator. Of course, that is through yesterday because these sentences commence today. There are a number of advisements I must go through. First of all, Mr. Brooks will be provided with a written explanation of determinate life sentence regarding the first-degree intentional homicide charges. Of course, he's not eligible for release to extended supervision. That form defines extended confinement for him, and there's other language on here that he can read at his convenience.
He won't read it.
He will be provided with the notice of right to seek post-conviction relief form. The court will fill out the caption for him. He is instructed to review it and review the defendant's acknowledgement, make the appropriate selection, sign and date it, and return that to the court. I must advise you, sir, you have been convicted of a felony. That means you may not vote in any election until your civil rights are restored. You may not possess a firearm. You may not possess body armor. Both of those are punishable as felonies. You also have 20 days from today's date to appeal the decision of this court. Does the state believe I've overlooked anything here today?
No, thank you, Your Honor.
What about you, Darrell?
Those documents will be provided to Mr. Brooks. I will note for the record, at many times during my final sentencing remarks, he was holding up an objection sign. That objection is noted for the record. This now concludes this hearing.
And it is denied.
In this case, we are now off the record.
Do you want to do the motion stay pending appeal, or we can do it another day?
I want to wait till I sign the judgment of conviction. Okay. I'm not making any determinations regarding where he is to be held. That certainly is within the, once the judgment of conviction is signed, I'll address the motion for stay pending appeal. But my understanding is he needs to be transported to Milwaukee, and I will not stand in the way of that. All right, I'll schedule that once the judgment of conviction is signed.
Understood.
We are in
Thank
recess.
you.
Thank you, everyone.
Thank you.
There you go. There you go. Get out of here, Darrell. You got a lot of rotting to do, buddy. You got a lot of rotting to do. Get him out of here. Hold on. I want to see this entire process. Put down the notepad, idiot. Let's get you in this little cell here. I have no idea what he's doing, why he's clinging onto this. Oh, they must have, okay, they got him chained to the floor. I'm so serious. This made my week right here. Listening to the impact statements broke my heart. And it was just difficult to really hear that stuff because I couldn't believe. It's one thing when you see how he's acting. When you hear what they actually dealt with. And I haven't even seen the actual parade footage, which I never will look at it because I don't think I could take looking at that. I am so happy. I'm just rambling right now. I'm so happy. This was the day where Darrell was officially handed. I know I rounded up all the time to 1,000 years. Darrell will never see the light of day again. I honestly don't know what to say. I'm gonna turn it to you all now, and I'm just gonna say thank you so much because you all have no idea how much doing this series really had an impact on my life in a good way, in every way that's good. Watching it with you all, experiencing this with you all, and frankly, I've said this before and it may sound a bit corny, I had no idea people like this existed. So it was one of these moments I started to realize, like, okay, there's a such thing as a sociopath and there's like an antisocial personality disorder, and like I didn't know a lot of things about the legal system. The amount of things I've learned from you all, the amount of love that I received while doing this series. I had people in my life that didn't enjoy the fact that I was doing this series, and ultimately they stopped talking to me simply because I was doing this series. But when I saw how much support I was getting and how much you all liked that I was doing this content, I didn't want to stop. So the only thing I want to say is I love you all. I mean that from the bottom of my heart, and this isn't the end by any means because I know Darrell is doing some appeal stuff, right? Like he's doing a lot of other things, and not only that, we have other trials we're gonna look at together as well. I just want to end it on that note. If you enjoyed the video, please like, share, and subscribe. I hope you did something good for somebody today. Hope somebody did something good for you, and I'll catch you all in the next one. Peace.